I've used it. And I wanted
Are we
to turn it
adjourned?
to you.
Well, is there a motion to adjourn, or do
So
we need a
moved.
motion to adjourn?
I suspect Bob would like to speak with us. And I
Yeah.
was kind of wondering why you didn't bring it up in new business, by the way. So.
Well, I'm not part of your commission, so I didn't want to interrupt your meeting. But I do have some views on the hearing that you recently heard, and have some feedback, and I have some continuing concerns about the financial matters that were involved in that. One of the issues I think you're aware of is that Jack Campbell's bill is being paid for by the county. And is that appropriate? Because that would seem to be attaining benefits that aren't generally available to the public or to any other member.
And he
of the
represented who? He represented the county commissioners?
He represented 8 of the legislators.
Legislators, were the commissioners.
Yeah.
Okay.
And his bill is likely to.
Is this a view, or is this the latest Woodward tone?
I'm sorry.
No.
There's some evidence in here that witnesses' statements that were made during the hearing were inaccurate. I'm looking at probably about 5 pages down. I think I have a chart. The dollar amount that I'm sorry, it's more than 5 pages down, it's about 8 pages down. Looks like this. I did an analysis, and I was able to get the billing records eventually from the county counselor's office. And they show that the county legislators have spent $4,211 on the counterclaim, according to the billing records. This is 4 times the amount that they admitted to at the hearing. They also are billing the county, James Workin specifically is billing the county $3,357.50 for his appearance and his work on the ethics complaint. And whether you feel that that's an appropriate billing for someone who's was hired to defend the legislators in court, not before the Ethics Commission. So I'm seeing that although the decision was to accept the dollar figure that was stated, it would appear that the dollar figure is quite errant. And the fact that the Campbell billing is expressly prohibited by your own rules, procedure rule 9.04 says that each party has the right to represent himself or at his own expense be represented by the council of his own selection. It would seem to me that would preempt the county from paying for those representation expenses.
I guess I have a procedural issue.
Yeah.
And that is this properly before us?
Right.
I mean,
That's just what I was thinking too.
without getting to the merits, I think that we have a procedure that allows us to review verified complaints. This is really more of an attack on, not an attack in a violent sense, but that's a word that is used in legal
I
things.
accept you.
It's an attack on the decision.
No,
And-
it's an attack on the process.
Okay, well, and let's put it this way. It raises issues that were previously decided, and there's a whole lot of procedural things here. Number one, is this in a form that we can deal with it? Number two, what does due process allow for the people who are you finished already? Do you have another copy for our counsel here who knows quite a bit about these things? and is very experienced in such matters.
What's this?
Yeah.
What's the
Oh,
deal?
you can have my copy.
That's okay. I got
I just gave one. I gave her mine.
Mr. Whippleston is raising some questions about the process and some of the outcomes.
The process of.
The hearing.
The last verified
last hearing.
complaint.
Oh,
Let me-
okay.
Let me clarify if I can. Is your point that our recommendations weren't followed? Is that part of the process that?
Well, part of my complaint.
Or is it that we didn't do something correctly, or our procedure that we used was not to your liking?
I think.
Hearing both.
Go ahead. You're
I'm hearing both.
Yeah.
I'm hearing that the amount stated in both the hearing and that was recorded in the Kansas City Star is inaccurate, and it is actually 4 times more than that. To that, I would say we didn't care how much it was. I wouldn't care if it was a dime or $50,000. That amount, as far as I'm concerned, what we said was that anything that was spent on the counterclaim absolutely had to be paid for by the defendants.
And you're absolutely correct. I agree with that 100%, except there's no mechanism to follow up to make sure that happened.
And I think then we try to find that out. I mean, I'm
That's-
speaking for the rest of my commissioners right now, but I really think that that's something we probably should follow up on. The second thing would be that we erred in the case of our own procedures. That's what I'm hearing you say, is in our own process and procedures that it would be up to the folks defending a complaint that they would be paying for their own counsel as opposed to the
The
county.
rules state.
That's what our rules state.
That's what our rules state about appearances before us.
Right.
Okay. However, I think that there is a bevy of case law and a bevy of statutory authorities for governmental employers to pay for the defense of governmental employees when there are issues that require a defense. I think we already found that out when we looked at that. That was part of our reasoning in the first determination, wasn't it? That it was proper for the county, or at least without saying proper, which is more of an evaluative statement, it was certainly legal for the county to provide a defense for legislators involved in litigation.
That sounds fine until you accept the fact that the county counselor's office, who arranged for this representation, also represents this commission, and that would be a conflict of interest for him to argue both sides of the principle. Basically, to come before a commission that has the authority to make a decision and to pile all its money on the defense of these individuals who are accused of doing something wrong. That seems to be
I'm not
like
sure.
like passing money to the judge and saying, "Oh, well, we'll listen to this case, but here, you take this $30,000 and you decide the issue." And
I'm not sure if I get the conflict of interest part. Say that again for me, if you would, please.
conflict is that the county counselor's office,
Yeah.
who hired the defense counsel for the legislators, and Jack Campbell, who argued in defense of the legislators, the county counselor is the advisor to this body.
Yeah, but the county counselor was not defending the legislators. Jack
They
Campbell
didn't have.
was.
They didn't have to. All they had to do was tell you what was appropriate to make a determination on.
What? That's
We had outside counsel.
yeah. We
Yeah.
had
But it was
outside-
also paid for by the county counselor.
So what? Would you like to chip in? I mean,
I have.
Well, your point is interesting, but it is not a conflict of interest.
Well, I see that it is. I see your argument being a little bit outside the scope of how the government operates locally. I see the Ethics Commission being different than, say, the Merit Commission, in which the county counselor is allowed to argue for the county's position to, say, terminate an employee. I could see that, because basically the Merit Commission is just the forum. But here you are the deciding body as to whether the complaint merits an ethical violation.
Bob, maybe this helps. We're a county agency.